So we were hoping today to give a little perspective on trust and estates litigation and how it actually informs our practice. So the types of things that we see, how they present themselves to us, and what we learn from those things. I would say most planners spend their career creating plans that maybe don't get tested. You know, sometimes they get tested because we file a 706 and we see if the tax planning worked, right? Or we're drafting the 706 and we look and say, oh, here's a cool reverse Q-tip election that we can make, or we can Q-tip this because the client moved out of state, and we can do those things and it gets tested. But lots of the planning that's in there goes untested. When we think about beneficiaries and clients' intent and what they want to do. Probate litigators, on the flip side, spend their careers looking at documents or situations that have failed. Right? There's a fight that brew, and their view of documents is completely different than the view that a planner often hits, and we're gonna see that today, I think, as we walk through some of our examples and our situations. So our goal today is we're going backwards. We're starting with disputes. We're not starting with planning that ends up with disputes. We're gonna start where the fighting happens. The phrase that I saw that I liked is, we're thinking of this as like estate planning with the autopsy in hand. Right? The events have happened, fighting is there, but now we get to look back and say, what went wrong, what went right, how did this end up going? So in some of that thinking, Matt and I have phrased it differently. I think of it as what walks in. Matt thinks of it as the phone rings. And if you know us well, you know that's an accurate thing because Matt answers the phone every time. Right? You have to walk in for me. Matt answers the phone. But so what walks in? What the phone rings? What happens? Right? What do we see? My brother doesn't tell me anything. Some assets are missing. Someone moved in with dad. Right? The trustee is bad. Right? That's where it starts. That's where those conversations starts. So I'll give you.
We had a couple of goals in mind for this presentation, and we can see where it evolves and how it goes. But one was just we will share with you when the phone rings or when someone walks in, how we respond, what we think about, how we advise clients, what our initial reactions are. And we were hoping to get to some higher plane. I don't know if we'll get there, but it's what's the feedback on our own estate planning? As planners, since we do high net worth planning, how is it that what we see in probate court will reflect on our own planning? And I do think we're in a unique spot. Most planners do not want to be near court at all, and they will call us and say, you know, this one's for you. But I do think that we think about this and talk about it quite frequently, and we see such planning, such bizarre planning, things that people think are throwaways, and they come back to haunt the family in ways that the planners never imagined. And I think we're quite conscious of those things because of where we find ourselves.
Yeah. So why don't we move forward? So one of the easiest places to stress test plans, one of the things that we talk to clients, almost all clients about, is protecting assets in the event of a divorce. And the planning hits the road there. It hits the road quick, and it creates a good situation for us to review with you kind of what we think about planning and how others think about planning.
So I'll just jump in and say that we talk with matrimonial lawyers all the time. I think I've spoken with 3 or 4 or 5 of them in the last 2 or 3 weeks, and they occupy a lot of our space because in my case there are 3 where fairly sizable trusts became front and center in a divorce. And so we joke about this, we talk about it all the time, and why is it? I think we come back to the same place, which is, this is very interesting for us. It's where our trusts get tested. We see if they work, and it's always in a divorce. And the law is changing, it's not static, and we watch as courts respond to it, and courts sometimes will whiff. They will completely miss the purpose of the trust, and we'll see it in real time. And we've been trying to keep tabs on it. We talked to matrimonial lawyers. Very interesting for us. And I do think it helps our practice, our drafting. It does inform what we do.
Yeah, and if you look at it from the trust and estates planning bar perspective, right, we think about how do we protect those assets? We're creating a lifetime trust for the benefit of a beneficiary, maybe beneficiary and their descendants. We're having an independent trustee in there with complete discretion to make distributions. That trust is going to last for their lifetime, right? On paper, we think that is a phenomenal trust from an asset protection standpoint and a divorcing spouse standpoint. That's our view, right? Sometimes beneficiaries will be co-trustees. Sometimes beneficiaries will have the power to remove trustees. And we think of that in the planning situation as like down the middle, right? Not risky, okay. But our friends don't.
We'll give you the punchline. We'll just give it all away right now, which is that we planners think about, we have this bias toward estate tax inclusion, and we think we know what a perfect trust looks like, and divorce lawyers think of it completely differently. And so if we give someone the power to remove the trustee, we say, oh, that's fantastic, it does not cause any inclusion, and they see a red cape waved in front of them, let's go, the divorce is on. We're gonna get that trust. One of them told me at a baseball field last night something like, we have a real problem here. And we think we don't have a real problem here, we have a beautiful trust. So there is this divergence in thinking, and it took us a long time to really appreciate it, that when we see a buttoned up trust, for us that means something very different from what they see. And so we're going to try to share with you exactly in very concrete terms what that looks like and what it means.
Right, well, you think of it in terms of, we think of grantor trust, and we think in grantor trust, somebody's going to have the power to substitute assets. Right, that's a good power. Maybe you have the power to remove and replace trustees. We think of those trusts in our good planning, and I think because Matt stays more informed and then we talk relating to planning. Courts get it wrong, except they don't get it wrong because they're the judge, right? We read cases, and I'll just talk about Ferry because it's not one of yours, right? So Ferry's an old case related to divorce where there was a decanting of a trust where a beneficiary had a full withdrawal right. I'm simplifying it a little, but that's okay. A full withdrawal right. Goes to the Massachusetts Supreme Court, and the Massachusetts Supreme Court says that decanting was okay. Like, that's great for that person, right? But it feels, it wouldn't have been your guess. Right? It wouldn't have been your guess in terms of how it came out.
So I will just tell you, matrimonial lawyers think of two things when they think of a trust. They think of control, a control test. Is there a control test? Arguably, from a case called Tremaine, does the beneficiary control the trust? And control, we will share with you, could mean anything. It could mean a crummy withdrawal right, as silly as that is. It could be the right to change the trustees. It could be a power of appointment, but it's a control test. That's what all divorce lawyers think. Is there a control? And then they look for a pattern of distributions. Is there support? How often were distributions made? That is all they are thinking about. And can they fit any trust powers into those boxes of control by the beneficiary or a pattern of distributions?
Keep up. I think let's dive in. You want to go New York, Massachusetts?
Oh, sure.
So let's go start with Netter.
Netter. Okay. So this area of law does evolve. We do see cases, and they're all data points for us as we watch courts try to wrestle with trusts. And I've often said that some courts don't know a trust from a bowling ball, but it's in front of them, and they took the bar exam, and it was there. But they are saying all sorts of things about trusts. Well, obviously, this is an asset protection spendthrift trust. It has it has vested rights and it's subject to defeasance. They're throwing in all the words they remember from the bar exam, and it makes no sense to us. What is this? So it is changing, and the case that everyone's talking about is Netter v. Netter. So this is the case that all matrimonial lawyers are talking about. One lucky person can take away a fresh copy of it. Netter v. Netter, matrimonial lawyers, and some estate planners are aware of it. So here are the facts very generally. There was a divorce in Connecticut, and high net worth family. And as the divorce was deteriorating, the husband moved $122 million of assets into self-settled Nevada trusts. Was it Nevada? Was it South Dakota? Nevada.
It's irrelevant.
Some state. Nevada trust, self-settled trust of which the husband was the beneficiary, $122 million. The husband was also the beneficiary of a trust created by his father 13 years before the marriage, and it had, I don't know, make up a number, $30 million in it. And the divorce, to say it was contentious, is an understatement. The court outlined all of the aspects of it, including, this is on appeal, that the trial was 57 non-consecutive days over 17 months. The court outlined the fees incurred by the husband in prosecuting contempt motions against him. So there was, as we put it, a jerk tax applied to the husband. He was an absolute jerk. I hope no one knows him. I'm sorry. I take it back. I'm sure he's a lovely
We've
person.
never met him.
We all have bad days.
Yeah.
So 157 bad days non-consecutively. So the trial court said, you know what? We are tagging the husband as the owner of all of the assets, not just the $122 million he moved into the self-settled trust, but the other $40 million that his father moved into the trust. And so $160 million is on his ledger, and it should be divided in the divorce. Well, that raises the question of how you're going to get it. Let's put that aside for a moment. This case went up on appeal, and that's what everyone is talking about. And so the appellate ruling is not the paragon of clarity in terms of legal reasoning, but it did help us a bit. So the court did say, look, the family trust is off limits. We're so glad to hear that. So the trial court said, look, he's got the power to remove the trustees. He is the investment advisor of the LLC that owns all of the assets in the trust. So it's part of the appellate court said, no, this is a classic spendthrift, multi-generational dynasty, put in all the words. Fine, all we care about is that trust was protected, and the language is pretty broad. And the husband did have reasonable powers to control the trust. He could change the trustees, and it didn't matter. The court came out in the right place. It did bend over backwards a bit to find that the $122 million in self-settled trusts are part of the marriage. Again, I don't know how you get them back. And the court made up a new rule. So as you may know, Connecticut does have self-settled trusts. We recognize them as of 2020, 2022,
Yep,
somewhere in that interim period where they were becoming effective. We have self-settled trusts, and the court made up a rule that was roughly, old self-settled trusts created before Connecticut's law outside of Connecticut that could violate public policy will be found to violate public policy if it prejudices us. Okay, I don't know what any of that means.
It just wasn't good.
It just wasn't good. There could have been other grounds for the holding, and undoubtedly this will go up to the Connecticut Supreme Court given the stakes. But I mean, I think in our world we would have thought of that potentially as a fraudulent conveyance at the outset. That husband could not have dissipated marital assets without consent. There seem to be other grounds that are more basic and more direct. But the court fashioned a pretty strange ruling. But as far as we're concerned, the family trust is protected, so we don't mind the Netter case so much in the end, or where it's settled right now.
Can I move you along? So you mentioned something good, and it's something that we'll do sometimes. A beneficiary is a trustee. A beneficiary comes in, and they're tell us they're getting divorced, and we might say, "Good time to step down as trustee. Good time to resign."
Yes, that's my cue. Connecticut had a case along. On the same baseball field, matrimonial lawyer said, "I had a case where the child was serving as her own trustee, and she stepped down right before the divorce." We say, "Brilliant. That's what you should do." Great.
You should do.
Perfect.
Good planning.
Textbook. Perfect. And he says, "No, we have a real problem here. We're going after the trust." So there is a case in Connecticut where that happened, and the spouse on the other side filed a motion to declare that a fraudulent conveyance, giving up the trusteeship, was fraudulently conveying an asset. This seems
No way.
Psychedelic, kooky, I don't know, creative. And the other side moved to strike, and the court said, well, I'm not ready to strike that yet. So it doesn't mean it has substance, but all of these little rulings give some weight to these arguments, and weight gives settlement value to them. So we have to keep an eye on them.
Right.
And so it's not nothing. Our playbook, which seems very, very traditional for us, we have to be very mindful of optics in a divorce. This is a whole other topic, but we obviously hope that they'll come to us.
And unfortunately, we're kind of left holding, right? Most likely that decision sits, doesn't get appealed, the divorce gets wrapped up, and that Superior Court decision just sits out there forever.
That's
and then in
last year.
5 years, somebody else is going to cite it.
That's in the
again.
past 12 months in Connecticut. And there are a few other ones, so you want to do those?
No, you're good at them.
I'm doing
Yeah.
them? Well, so there was a case 3 years ago in Massachusetts called Jones v. Jones, and we were keeping an eye on it, and it effectively said this. dad dies, creates an estate tax shelter trust. Mom is the beneficiary of it, as you might expect. Let's call it a marital trust. Mom is the only beneficiary. On mom's death, it's going to be divided outright to 3 children. Okay, so standard facts. One of those children, the daughter, is getting divorced. And the Massachusetts court said, we are going to count 1/3 of that as an asset of the daughter. 1/3 of that.
Currently.
Mom is alive. Mom is in great health. Mom is doing fine. We're going to, count one of it currently as an asset of the daughter.
Well, that's fine. You must have discounted it to present value.
No discounting. Just 1/3 of it. It's yours. Why? Because it's a vested right subject to defeasance. I don't know, more language that makes no sense in our world. And we thought, oh, Massachusetts. But actually, we didn't quite think that because we have a problem. Our clients may have children who may live or move to Massachusetts. We were tapped into this. We were actually shocked that we wrote on it immediately. We heard later on that some of the New York firms had heard of it too, and they were also worried about it, but seemingly no one was taking notice. And then there was a 2025 case. We thought, no way that this can come down I-95 to Connecticut, oh, Massachusetts. But it did. We have a nearly matching case in the last 12 months in Connecticut. Similar, almost exact facts, same result. It is now in Connecticut. It's a lower court case, but again, often there isn't enough juice to appeal it. It may just sit out there. So it does exist. It does frame how we think about this.
Maybe before we jump in, maybe we just talk quickly about HEMS, Health, Education, Maintenance, and Support. Look at that, you have it highlighted. So our 2020 trust code literally has the language that says a power, whether mandatory or discretionary, held by the trustee of a trust, including a power held by the beneficiary, has the sole trustee. So a trust for me, I'm the trustee and the beneficiary, and I can have distributions for health, education, maintenance, and support. It says what, Matt?
So why is this relevant? We talk every day about lifetime trusts for children. Of course we do. We talk about full discretion and who's going to be the trustee, who am I going to name? Should it be my brother? Is he the right age? Should we have a financial institution step in? Can my children be trustees for one another? Not a good idea. Okay, we talk about this all the time. And then the question is, well, could they be their sole trustee? Well, under Connecticut law, as of 2020, they actually can be. And the black letter law says that is a protected trust. It says explicitly, even if the beneficiary is the sole trustee and is making distributions for HEMS, it is protected from any creditors. It says that in black and white as of 2020. Clear. Very clear. Does that make us comfortable? Not too often.
It did in the beginning.
Momentarily.
It did.
But, for any number of reasons, you could imagine a matrimonial court saying, well, that's all very well and good, but I'm the lord of this domain, and I will decide what's marital property. And again, children move to other states. It's not hard to imagine that a court in Massachusetts might say, that's great for Connecticut, but I'm in charge here.
Yeah, no, I think
makes us nervous.
It's just one of those things that's out there that we know, that's impactful, that we have to think about in planning, and it's helpful for us when you think about it or have a little bit of knowledge when you're talking to your clients about it as well. Do you want to hit quickly on the married?
I guess I would say it's hard to imagine that in a divorce, this would fully protect you, because you can imagine the matrimonial attorney saying, well, where's the logbook where you show all of your distributions coded for H, E, M, or S? And if you don't have it, I think you've overstepped. You're outside the statute, right? Right. And I think this has created a little bit of feedback in our planning. I know that I am talking to the next generation more and more often. Even if it's 10 minutes to say, Mom and Dad set up some trust for you. We hope the time doesn't come anytime soon, God willing, many years from now. But when it does, maybe we should just put it in your mind that we should come in and talk about administration of the trust. But it's hard to imagine that they will adhere to this closely enough that it wouldn't cause risks. I do want to talk for a moment about divorce between a husband and wife who did planning during their marriage. We often think of the paradigm case of the child, but when husband and wife are getting married and they did the planning, that case has come up more and more frequently in the last 12 months or since we last did this presentation. I think there are a couple of takeaways just to file away. One is, you can't imagine how many times we see a trust that is drafted and it says my descendants and husband is the grantor and it's his descendants. I've had 3 cases in the last 12 months where husband had a child out of wedlock or during wedlock with someone else. And there all of a sudden are additional heirs in the mix. Again, you could allege fraud, that was not the intent of it, but the trust is defined as descendants and with respect to husband. What sense does that make? I don't know that it makes much sense, especially less sense if the asset in the trust is the family home, it's a Cupert, or they put part of the family business in it, or assets that derive from the wife's family and her wealth are in the trust, and it's now defined as descendants with respect to husband. That is a messy situation, and it comes up all the time. It is as tawdry as you might imagine. 68-year-old, during the pendency of the divorce, his girlfriend is pregnant. It happens all the time, 3 times in the last year. There's another part of it, which is the removal power. Sometimes this is a throwaway in the document, or it says, in the event of divorce, wife shall be deemed deceased. Again, what sense does that make if you're putting marital assets in it? People think of these as a throwaway, but it's absolutely not. So during the pendency of the divorce, husband has the power to, or wife is deemed deceased, and the family business is in the trust. I have 2 or 3 of those that have just popped up. And I would say I would analogize that to a number of cases I've seen recently. Well, I've got 2 of them where husband, I will just abstract a bit. Husband is dying, he redoes his estate plan, perhaps the marriage is on the rocks, and he names his sibling as his executor or trustee. And the drafting firm has a throwaway provision in the back that says, oh, the spouse shall have full discretion to remove the trustee at any time for any reason. Was that intended? It's hard to imagine that it was, but you can see the mess that it's made because husband, with the clarity of imminent death, has decided that the sibling is the right person, and then the sibling faces a removal action from the spouse who was not named. So these things do fit together. We see them in different contexts, but divorce is a good illustration. All right, where are we now? Go.
No, I think that's great, and I think it's perfect because it's where we see trusts in litigation on a regular basis, right? And it's one of those things that clients want. They want protection. It's something that we talk about, and it's tangible. So let's move on, and let's go a little faster. Faster. So the phone rings, Matt.
The phone rings. So Michael redid this slide this morning. So there it is. I didn't. All right. This is the lightning round. I saw a link go out, but I don't know. Okay. Lack of information.
So a phone call comes in, generally something along the lines of, my sibling's the trustee. I don't know anything. What's going on? I have no information. Death's been recent. Death's been a while ago. Something along those lines, right? And I think from one perspective, that from the litigator's perspective, it's very important to stop, right? To breathe. We got stress balls today at Wigan for Wellness Week, so we can use our stress ball, which was nice. And then talk about the role, the person's role, the fiduciary's role in timing, right? So just trying to level set, give expectations. So if it's an estate administration, is it weird that it's been a year since you've heard anything, or it's been 3 months? Has it been 10 years, right? Trying to level set some of that information and provide some level of education relating to where we're going, what we're doing. But then what do we do if we need more information?
So I think that's a very helpful starting point. I think when we do presentations, I feel this need to deliver as much content as possible, but not when the phone rings. When the phone rings, I think we need to slow down the client very much. And I do think that, not to give away too much of our playbook, but there is incredible value in trying to impose an order on a family dispute. And the other party, your party, the other counsel, they may not be in the business of doing that. They may think that their job is to bang the table, especially when there are estate planners who don't know litigation or litigators who don't know estate planning. They come in and it's not the right fit, bull in a china shop, and that does not necessarily help anyone, and it doesn't play well in probate court. So I think for all clients, we're saying, look, you want to succeed in probate court, you have to focus on the big picture, and our job is problem solving. The court wants to look to us as the party that is solving the problem, and we want to have a conversation directly with the judge, and we want the judge talking directly with us. The other party may be irrelevant, and if we get to that point, we are going to win the case. So we're having a discussion with the judge on practical solutions, and we need to be practical about your problem and put it in context. So when a client comes in and says, I don't know anything, our circuits are flashing. Of course, we're going to frame this as an accounting action, but maybe it's not an accounting action immediately. Maybe it's a discussion of what information you need. We certainly want to posture and be in the position of being the party looking for real answers to real questions. That's how we start. So it could be an accounting action. We typically have the right to get one. We typically get an accounting if we're the right party to request it, but not if it's only been 3 months and there's complicated assets and dad just died and prospective client just wants to know what they're getting. You're jumping the gun a bit. We're not going to request an accounting.
Right. Let's just skip around a little. So from there, maybe we've requested accounting. Sometimes people call and simply hate their trustee, don't like their trustee, haven't heard information from trustee. They want to get rid of their trustee. Again, on the education side, but then we move, they want to get rid of them. So it's trustee removal. So when somebody comes in and wants to talk to us about trustee removal, what do? Generally, our first step, Aaron and I actually wrote a nice little article on this. Generally, first step is read the document, right? It's amazing how seldom people have actually read the document, right? Is there a removal power? Do you have it? Is a protector appointed to exercise it? Like, read the document. And then number 2, have you had a conversation with the trustee? Right? Have you asked? Have you asked for the more information? Have you said you're unhappy? Like, what are the reasons? Like, you have to have that conversation. And then if you don't, if those things fail and you're moving towards removal, in Connecticut, removal looks kind of easy by statute. If you have all of the beneficiaries agreeing and it doesn't violate a material purpose, you may in fact be able to get removal. But Matt, is it that easy?
No. And I think context is very important. So if your beneficiary relies on the trust as their sole source of support, and their uncle is the trustee or their sibling, you have to take this with a bit of caution, because they're going to turn the screws and maybe turn off the distributions. But putting aside that context, to talk about it purely as a legal issue, there is on the books a sort of no-fault removal in Connecticut, both by case law and endorsed by the Connecticut Trust Code. But no, it's not that easy. There is incredible deference. Probate judges do not like to remove trustees, as I found, even when they've been acting in the most egregious ways. There's like, well, could we talk about this for a while and let's see where it goes? So it is difficult. And if you're in that context of, relying on the trust for support, there is this notion that if you're going to shoot at the king, you better hit, because if you lose, it's going to be miserable, and you're going to be stuck with them for a while because you've just been in probate court, you've taken your best shot at it, and you're going to have to wait for years to gather evidence of bias and misdeeds and start again. It resets a whole clock on you. But there are several grounds. There is persistent failure to administer the trust. There is incapacity. And the most frequent one is failure of co-trustees, of co-fiduciaries to act together. And in that case, you have to warn the client that if you go in, the likeliest outcome is that you both get knocked out. And sometimes that is what we want. Sometimes we're more than happy to say, look, enough of this nonsense. It's expensive. Let's get a third party, and we know that it's going to be a friend of the court. It's going to be, and you name the court, and we can guess who the 4 or 5 candidates are to be appointed. We know where that's going, and sometimes taking that chance, rolling that dice on those 4 or 5 is better than proceeding with your brother who's been a nudge.
So
okay,
I think we should hit 2 more.
Go.
We're gonna hit 2 more. Which one? You like thinking blended families, right? Trusts that last too long, right? So we'll have, maybe it's a marital trust. And the surviving spouse, say mom or not, lives much longer than expected. They often brew fights, right? There's often not a lot of information shared, or they're questioning distributions, they're questioning investments. Maybe we're investing, income's coming out, so they invest heavily for income. So it's a fertile ground for disputes.
Whatever would we know about that, Michael? Whatever. So the marital trust that lasts too long is the new classic estate dispute, and it's like Greenwich, a wife with 5th husband, and he's lived for 20 years, and he's remarried 3 times in the interim, and all the assets are in there, and they're businesses or they're not, and there's always the tug between, the remainder beneficiaries are now in their 60s or 70s. They haven't seen a penny of mom or dad's estate. They're waiting for 5th husband to die. he is investing in real estate or he wants a jet ski, God knows why, he's 80, and it doesn't make any sense, and so that is an expensive and slow dispute. There are tax consequences, so most litigators don't appreciate that this is a technical issue. There's a commutation of a marital trust that is quite technical and it could be quite punitive, and they just plow ahead and say, well, we'll just take this and you take that. It's actually a technical issue as well as a litigation one. What else to say on the marital dispute?
I think that's good. I think that's good. Let's finish with multi-state conflicts. Right? I think sitting here in Greenwich, we see that a lot. We have maybe trusts that exist. We have families with trusts in New York, families with trusts in Connecticut. We have families that have gone to Delaware, South Dakota, Wyoming, Alaska, wherever you want to go. And some of those trusts will have provisions that say if you come after the trustee has to flee, right? I'd like to see that. But those sorts, so we've been involved in a number of cases. We've had one that was it was a probate estate. We had Connecticut Superior Court action going on at the same time as Delaware action going on, the same literal trust. And what we see now is those multi-state fights happen. Sometimes a trust will state where its governing law is, right? Always a trust should state where its governing law is. But your selection of fiduciary may impact where you can bring an action. I mean, sometimes you have more than one choice. Maybe if it's a Connecticut person created the trust and they created a Delaware trust, they may be able to have a probate accounting action in Connecticut. That trustee is going to try to move the action to Delaware. And I think just knowing that sometimes these matters get messy simply based on that ability to move.
So you could easily imagine a situation where you did a beautiful IDIT sale and the entire business has been pulled out into a multi-generational trust and there are 3 children or 4 or pick your number, and one of them said, I'm tired of this family, I'd like to liquidate and take my money and not be tied up with the family, I want to go elsewhere. I'm the beneficiary on paper of this massive trust, and yet I'm getting assets doled out to me by my uncle who's the trustee. How do I monetize? How do I, for my own, I'll make it less nefarious. For my own sake, how do I diversify my financial interests? How do I think of my own planning? And what does beneficiary do? He sues in multiple jurisdictions. Home state of business, site of the trustee, requests an accounting where a grantor lives. I mean, we see this. And what's my reaction? I don't know. We have to take it as it comes, but I do have a bias toward trying to bring something in Connecticut, perhaps an accounting action or some sort of status conference, because our courts move quicker and because the judges know us. So like we have some home court advantage, but also because the courts move more quickly and we're looking to solve problems. So I had a case, you might have multiple litigations pending, and but other courts are slow and discovery has started, and the question, you come into Connecticut court and say, can't we just talk about this? This is incredibly inefficient. Are you really going to proceed with discovery in multiple jurisdictions? Isn't this really a trust dispute? Shouldn't we talk about some sort of division or of the trust? And you might actually get some traction. And if you get some traction, it might make the beneficiary a bit nervous. In my scenario, in my head, I'm representing the trustee. Might get a bit nervous about all those disputes that were filed and might see Connecticut as more of a fast track that might run some of that off the road. So I do have a bias if it's multi-jurisdictional to try to move something, and Connecticut often is the quickest thing to move.
Great. Well, thank you, Matt. I am fully energized and ready to go.
Yeah.
Our goal really was to show you the complexity of a number of the things that we do and we see, the complex problems that come out from it